This class provides a brief introduction to legal issues in business analytics. The module begins with an introduction to tort law, contracts, licenses, and copyrights, but focuses on data protection and privacy regulation. It concludes with a brief view to AI-specific regulations that are proposed in Canada or have already taken effect in the European Union. The class takes a Canadian perspective. Canadian tort law is based on common law in the English tradition. As such, some of the concepts and issues discussed in this chapter may be applicable to other common law jurisdictions in the English tradition. On the other hand, the law of the province of Quebec has a different tradition, and not all common law concepts apply there. Similarly, the section on copyright law focuses on Canada, although copyright law is internationally relatively harmonized, beginning with the Berne Convention of 1886 and through the ongoing activities of the WIPO, World Intellectual Property Organization, such as the WIPO Copyright Treaty, 1996, to which most countries are signatories. The section on information protection and privacy focuses on Canadian federal regulation that applies to commercial activity within Canada. A different set of regulations apply to Canadian federal and provincial governments. Many other jurisdictions around the world also have information protection and/or privacy regulation that may apply to Canadian businesses operating in those jurisdictions, but that may be significantly different from the Canadian regulations. The final two sections discuss Canadian and European Union (EU) legislation around the use of artificial intelligence systems. The Canadian legislation is proposed and, at the time of writing, September 2024, is working its way through Parliament, while the EU legislation is in force. A tort is a civil wrong that causes harm to an individual. Tort law governs such civil wrongs or injuries other than breach of contract and the remedies for such wrongs and injuries. Torts are typically categorized into torts against the person, property torts, economic torts, dignitary torts, and negligent torts. This section does not provide a comprehensive discussion of tort law, but only briefly discusses some torts that may arise in the context of business analytics. An important general concept in tort law is that of vicarious liability. In particular, employers may be liable for the negligent behavior, actions, and omissions of their employees. This liability hinges on the definition of an employee versus an independent contract, which has become somewhat blurred in the so-called gig economy. Various tests of employment relationships have been devised and applied by the courts, typically focusing on the exclusivity of the relationship and the level of control exerted by the employer over the employee. An example in the context of business analytics may be large-scale data collection efforts. For example, Google's Street View program may use a fleet of car or bicycle drivers that may, through their actions, cause significant harm. Whether the drivers are employees or independent contractors is of importance in assessing the risk. Moreover, the potential harm is not only associated with the risk of traffic accidents, but also potentially other torts such as intentional trespassing or invasion of privacy, intrusion on seclusion. In these cases, the employer may be vicariously liable for the injuries caused by their drivers. Damages that can be awarded in tort law are compensatory, which compensate the injured party financially, and punitive, which are intended to punish the injuring party and deter similar future actions or omissions. The difference is important in that compensatory damages may sometimes be so small as to be considered the normal cost of doing business by the injuring party. Hence, punitive damages may be awarded that amount to a significant cost to the injuring party in order to form an effective deterrent. Courts may also order an injunction, that is, they prohibit a party from engaging in certain behavior. Among the intentional torts, invasion of privacy, intrusion on seclusion, may be the most relevant to business analytics endeavors, especially with respect to permissible modes of data collection. Intrusion on seclusion requires intent to intrude, judged subjectively based on the knowledge of the intruder. The tort also requires the intrusion to be highly offensive, judged objectively from the perspective of a reasonable person. Finally, the tort requires actual harm, for example, in the form of anguish or emotional suffering. Intrusion on seclusion can be physical, for example, drone-based video collection over private spaces, or virtual, for example, data scraping off websites or illegally accessing databases. Another example is that of employees inappropriately accessing private information held by their own organization, employee snooping. However, the standards for offensiveness and actual harm are often difficult to meet, and other privacy laws may be more applicable in typical cases. Breach of confidence is the tort of disclosing information that is secret, confidential, or private, and that was communicated in a situation that implies or imports an expectation of privacy and confidence. The tort requires this information to be of some value or importance, and the disclosure to third parties must have caused actual harm. Here, too, the standard of actual harm may be difficult to demonstrate, and other privacy laws may be more applicable in cases of unauthorized information disclosure. An example in the area of business analytics could be the disclosure of confidential personal information by a data processor to a competitor, with reputational harm to the data owner due to customer complaints, or economic harm to due increased competition. A related tort that has recently been recognized by the Alberta Court of Queen's Bench and the Saskatchewan Court of King's Bench in 2021 and 2022, respectively. The public disclosure of private facts involves publishing an aspect of private life in some form that is highly offensive and is not a legitimate concern to the public. Importantly, both courts determined that the tort is actionable per se, that is, without showing actual damages. As an example, in the context of business analytics, this tort may arise by publishing a person's medical information with the intent to embarrass or cause reputational damage. Trespass to land is the interference with another's right in real property. An example in the business analytics content may occur through video or other sensor data collection. For example, the property rights above land typically extend to some portion of the lower airspace above it. Modern drones commonly use such heights in overflight and may cause interference. However, this tort requires direct and physical interference, a standard that routine data collection behavior may not rise to. Indirect interference is covered by the tort of nuisance. Important defenses against these torts are consent, assumption of risk, or contributory negligence. Both consent and assumption of risk can be expressed or implied. Express assumptions of risk or consent typically take the form of a waiver of liability. However, liability waivers must describe specific risks and can absolve a defendant only of liability for negligent but not reckless conduct. Implied consent is given when a specific harm may be ordinarily or reasonably expected, and a person continues to engage in a particular activity. For example, implied consent to data collection may be provided by an online retailer clearly describing the data collection that occurs, and a clear statement that continued use of the service implies consent to that data collection. Contributory negligence is the concept that negligence, that is, failure to take reasonable care by the injured party, contributed to the injury or harm. This typically leads to some apportionment of loss when both parties contributed to the harm. To summarize, the torts described here are intentional torts. An organization or individual must demonstrate intent to harm or injure another party. Additionally, most of these torts are actionable only when harm or injury has actually occurred. Negligence is the failure to exercise appropriate care, that is, the breach of the duty of care. A duty of care typically exists where harm or injury is reasonably foreseeable and where there is a required degree of proximity between the injured party and the defendant. Typical situations in which a duty of care exists are employer to employee, manufacturer to consumer, provider to customer, etc. Throughout the common law countries and jurisdictions, a number of specific tests for the existence of a duty to care have been developed and applied. Negligence requires a breach of the duty to care and a causal proximity to the incurred loss, injury, or harm. Causal proximity means that the particular action or omission was the direct or indirect cause of the injury, but at the same time was not too causally remote or the causal chain interrupted by another event. An example of negligence in the context of business analytics may be injury caused by decisions or actions from a predictive model if the development or operation of such a decision tool was negligent. For example, the organization failed to examine training data for bias or failed to appropriately test the finished model. Another example is a data breach by a company that fails to apply security patches or updates to its software, or fails to follow industry security guidelines, and as a result suffers a data loss with consequent injuries or harms to its customers. Product liability is a subset of strict liability in Canadian tort law, which holds manufacturers, distributors, or retailers liable for harm caused by defective or dangerous products, regardless of fault or negligence. With strict liability, the focus is on whether the product was defective or unsafe rather than on the conduct of the defendant and whether the duty of care was breached. In Canadian law, a product is considered defective if there is a design flaw, manufacturing defect, or insufficient warning about its potential risks. In such cases, strict liability allows an injured party to recover damages without needing to prove that the manufacturer was negligent. In the context of data analytics, strict liability can apply to software products or platforms that handle sensitive data, where defects in the software lead to harm. For example, data analytics software tools should meet high standards for security, reliability, and accuracy. A defective product in this area could lead to data breaches, financial loss, or reputational harm. Consider a retail company that purchases data analytics services from another company to predict customer behavior. A design flaw in the prediction algorithm means that the retailer consistently misses out on sales as it overprices its products. Defenses against claims of negligence are assumption of risk and contributory negligence, as discussed above. Contracts are important in many areas of business analytics as they govern the purchase or sale of data, the licensing of data, the collection or creation of data, data processing and data manipulation, the provision of access to or use of analytics services, etc. While the foundations of contract law are important to business analytics, they are not specific or unique to this area. Contract creation in the English law tradition concerns concepts such as offers, willingness to contract with the intent to become binding, invitation to treat a pre-offer communication, firm offers valid for a particular time, counter-offers, battle of the form, conflicting terms in offer and acceptance, revocation of offers prior to acceptance, and acceptance. Contract law introduces the concepts of consideration, the objects or services being exchanged. Contracts must involve mutual consideration. Privity, being party to a contract. Contracts cannot confer rights or obligations on third parties. An assignment of rights or benefits by one party to another. The law clarifies what form an offer or acceptance must take, how offers, revocations, and acceptance must be communicated, when and whether an offer is deemed to be accepted, etc. For electronic commerce in Canada, the Uniform Electronic Commerce Act, UECA, provides legal recognition of electronic documents, ensures that electronic contracts are enforceable, clarifies electronic communication modalities in contract formation, sending and receiving of electronic documents, and addresses the use of electronic or digital signatures. Specific issues in business analytics sometimes arise in the description of what is being purchased or sold. In particular, data can be sold, that is, the copyright can be assigned to another party, or it can be licensed for use, typically with limitations and restrictions. Data sets may be provided in their entirety as copies, or data may be accessed as needed through electronic means, for example, on a subscription basis. In the former case, the contract may specify the rights that are transferred and any limitations on use of the data. In the latter case, the contract may specify the access modalities and rights and obligations of each partner in making available the service and responsible use of the service. Often, data contains personal or protected private information, and contracts should contain clauses that specify whether and how such data must be protected. These contract clauses may specify technical or administrative measures, audit and oversight rights, or prescribe employee training and education. In business analytics, processing services may be offered and contracted, for example, for data cleaning, data pre-processing, format shifting, etc. Analytic prediction models may be sold and purchased. For example, trained models are copyrighted, and this copyright could be assigned, or a license could be issued, or the model may be accessed to make predictions. For example, when real-time access to a predictive service is purchased in a contract, the buyer should include a liability and indemnification clause that holds the provider liable for wrong or misleading predictions and any injuries suffered because of it. Contracts for accessing services may also specify service levels and performance standards. As an example, a contract may specify the required availability and response time for a real-time prediction service to ensure the service provider maintains appropriate service level. A contract may also impose rate limits for the number of requests per time unit on the part of the service consumer. In all these cases, the issue of quality of data or of a service is important but often difficult to specify in contract terms. For example, how should the quality of a dataset be defined so that it can be objectively measured by all parties to the contract? How should thresholds for acceptable quality be set that are unambiguous and understandable by all parties? How should the quality of a trained predictive model be defined? Are there considerations beyond the validation or test error? Who provides the validation or test data to assess the quality? These questions show that considerable effort must be expended on defining appropriate contract clauses. A license is the permission to use or do something that would otherwise not be permissible. Licenses are transferred as part of a contractual agreement between the rights holder, licensor, and the licensee. A typical use of licenses in business analytics concerns the use of copyrighted material, such as datasets, trained prediction models, or software applications. Licenses can be exclusive, sole, or non-exclusive, ordinary. An exclusive license differs from a sole license in that an exclusive license also prohibits the licensor, rights holder, from engaging in the licensed activity, while a sole license means that only a single license is issued, but the rights owner can also engage in the licensed activity. Contractual agreements may specify the license to be revocable by the licensor or to be irrevocable. Licenses may also be time-bound, that is, they have an expiration date, or they can be in perpetuity. Time-boundedness is independent of revocability. For example, a license in perpetuity may be revocable, and an irrevocable license may be bounded in time. Licenses may be transferable by the licensee to another party or non-transferable. Licenses may also provide a limited option to sublicense to a third party. When a license is transferred, the original licensee is no longer permitted to engage in the license activity. That is, they no longer hold a license, while in the case of sublicensing, the original licensee retains a license. Licenses may grant specific rights or may permit all uses that are normally the right of the author or copyright holder. Licenses may also provide conditions or restrictions for engaging in the license activity, and termination of the license when the licensee fails to meet such conditions or violates the restrictions. Finally, licenses may provide or explicitly exclude warranties or provide indemnification clauses. Copyright law governs the rights of authors of an original work in the sense that the work originated with the author. The scope of what is copyrightable is rather broad, but importantly, it does not cover ideas but must involve a fixed, tangible form. Copyright in Canada includes the rights to reproduce, copy, distribute, publish, and to translate or adapt a work. In the context of business analytics, questions may arise with respect to what is copyrightable and whether an activity is reserved for the rights holder. For example, a fact itself is not eligible for copyright protection as it is not an original work, and neither is the simple collection of facts. However, once a collection is curated, that is, some items are removed while others are retained, transformed, or otherwise processed in a manner that involves skill, judgment, or creativity of an individual, the result does constitute an original work eligible for copyright protection. For example, data that is indiscriminately and automatically compiled. For example, a recording of raw sensor data or the raw text collected by an automated web crawler bot may not be afforded copyright, but subsequent data cleaning, pre-processing, or feature engineering may make the dataset eligible for copyright protection. A particular issue where copyright law may be unclear is the use of data for the training of predictive models. In particular, the question of whether the ingestion of data into model training without making a local copy of that data constitutes reproduction, adaptation, or translation is not yet settled in Canada. Consider text data that is immediately submitted to a tokenizer, converted to integers, and then processed by an embedding layer, all without a copy of the original text being retained. Moreover, the Copyright Act allows temporary reproductions for technological processes, given that the reproduction's only purpose is to facilitate a use that is not an infringement of copyright, and the reproduction exists only for the duration of the technological process. Canada Copyright Act Section 30.71. Websites provide a lot of information that is useful for business analytics. Assuming that the data presented on a website is eligible for copyright protection, the rights holder can limit or prohibit its use by issuing or withholding licenses. Typically, websites provide terms of use for these purposes. These terms are human-readable documents that specify what rights are given to persons accessing the website. Terms of use are typically considered valid if clear and reasonable notice is given to them. For example, by requiring explicit acknowledgement or by providing a conspicuous link to them on a website. However, large-scale web data collection does not rely on human users accessing and reading websites. Instead, it relies on automated software applications, so-called web bots or crawler bots or simply crawlers, that access the content of a web page, process it, and follow any links from one page to another. Crawlers were first devised by the early web search engines such as Yahoo or Google to populate their search databases. However, web crawlers are not limited to search engine use. They are now also used, perhaps primarily, to collect data for analytics. For example, text mining, social network analysis, or collecting image data for the training of predictive models. To help control or limit access to the information on a website by crawlers, websites can use the Robot Exclusion Protocol, commonly referred to as the robots.txt file. Originally devised in 1994 and formally standardized in 2022, a robots.txt file for a website specifies in computer-readable format which crawlers or bots are allowed to access which portions of a website. However, while standardized, not all crawlers obey the limits specified in the robots.txt file, and organizations should also consider other measures to prevent unauthorized data scraping. For example, by configuring their web server to block or ignore such requests or to set access rate limits. The figure in the slide on the left shows an excerpt of the robots.txt file of the YouTube website. The directive user agent specifies which type of crawler or bot the following directives in the file apply to. The disallow directive excludes certain portions of the website. For example, the YouTube robots.txt file in the slide on the left allows the media partners Google bots access to the entire site. That is, it does not disallow anything for these bots. In contrast, all other bots are disallowed from certain portions of the site. Contents of the site that are not disallowed are deemed to be allowed. In contrast, the directive allow, not used in the example, works by explicitly permitting access and deeming all not allowed portions to be prohibited. Finally, the crawl delay, not used by the example, can be used to specify a minimum time, in seconds, before a crawler should access the site again. In summary, the robot exclusion protocol through the robots.txt file provides access limits to automated web crawling, but adherence to this protocol by a crawler or bit is voluntary, and not all crawlers understand or honor all directives. Importantly, the directives in this file are not legally binding.